When you bring a lawsuit seeking compensation for the harms and injuries you suffered because of someone else's carelessness, why is your attorney allowed to allege multiple theories of liability, multiple theories of wrongdoing? You want to know why I bring this up and why it's important for you as you're contemplating bringing a lawsuit here in New York? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So there was a crazy case recently involving a former NYPD cop who allegedly killed his girlfriend. And now he's in the subway station, falls onto the tracks, a train runs over him, he loses both of his legs. He now goes ahead and sues the Metropolitan Transit Authority, the MTA, claiming that they were careless, that they were negligent. And in that claim, for $50 million, he says, hey, I'm not responsible. The MTA is responsible for cutting off my legs. Now, you might think he'd know how this incident happened or why the MTA would be responsible. Well, according to the New York Post article recently, he talks about 4 different theories, 4 different ways that this could have happened, that they might be responsible. This is fascinating. So first he says, the guy has no recollection of how this incident actually happened. This is even better. So we mentioned 4 things that could have happened according to his attorney. That he was either jostled on a crowded platform. Number 2, he slipped on something. Number 3, some debris fell on him. Or number 4, the train conductor should have been able to stop in time. Those are the 4 different theories of liability, and what's fascinating in this particular case is that this guy has no memory of exactly what occurred. So someone from the New York Post who was interviewing this attorney said, well then how do you know he wasn't trying to commit suicide and that this is all his fault? And you know what the attorney said? He said, that's a good question. Damn right it's a good question. It's an excellent question. Because if he's trying to commit suicide, then the MTA would not be responsible at all. How is it that we're permitted to allege multiple theories of liability? Well, the reality is in law, there are some instances like this one where the injured victim doesn't know precisely how it was that they suffered this injury, how someone was careless. So the law actually allows us to allege multiple theories of liability. And then at trial, it is our obligation to show that we are more likely right than wrong, that what occurred is actually true, and that this person was careless or this company was careless. And if we don't have the evidence to support each one of those theories of liability, then the jury is obligated to tell us that in their verdict. And by the way, you should also know that if we allege multiple theories of liability, we only have to show one of them in order to be able to obtain a verdict in our favor and obtain compensation. So why do I share with you this great information? I share it with you just to highlight this crazy story and importantly to show you how it's possible to allege multiple theories of liability when you don't know precisely how it was that someone was careless. You know, I recognize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.